Good morning, everyone. My name is Shantanu Majumdar, and I'm yet another member of Reaccurate Chambers, albeit rather more on the commercial dispute resolution and fraud side than hardcore insolvency. And I only mention that because I'm expecting to learn something in the next 40 minutes or so, and I hope that you will too. In this session, each of 5 of the most junior members of Chambers has chosen an insolvency case from 2020 and is going to spend 5 minutes trying to persuade you that case is more important than the others. We have a varied diet of subject matter, from extraterritorial jurisdiction under the Insolvency Act to the interface between insolvency and construction adjudication. And the decisions also range across the tribunals from the, I won't say lowly, but certainly familiar ICC list, right up to the Supreme Court. And although the cases were not chosen for this reason, for what it is worth, I should say that 2 of them involve other members of these chambers. If I'd had my way, we would have had a no repetition, hesitation, or deviation rule. And I even toyed with the idea of a Biden-Trump style debate with fraying tempers and insults traded. Our juniors really do feel that strongly about insolvency. You can decide in due course who would have called whom a clown. But I was comprehensively outvoted. How democratic Chambers has become. On the subject of voting, there will of course be a poll at the end. I shall be very interested to see how it pans out. We will try to accommodate questions if there is time for them right at the end. Finally, I'm not going to say anything about the speakers by way of introduction, more than names. There isn't time for that, but in any event, they're about to show you how good they are in the most convincing way possible. Apart from anything else, we shall discover whether brevity really is the soul of wit. First up is Jonathan Edwards, who's going to talk about the decision of the Chancellor in Reaccurate Limited. Jonathan.
Thank you, Shantanu. So this Reaccurate was an English company and it was in liquidation. And the liquidators wanted to inquire into its affairs because there was a dispute about the use of the company's trademarks in the period immediately after its liquidation. And there was a suspicion that there was collusion between former directors of the company and the people who'd actually been making use of the trademarks, who were in particular companies in Italy. The liquidators wanted to look into that, and they were looking for information and documents from Italian companies. And they sought to proceed under Section 236 of the Insolvency Act. And I think one of the reasons why this case is an important one is that Section 236 comes up all the time. It's very often a first step that insolvency practitioners look to before they launch more substantive legal proceedings. So it's a potentially very wide-ranging relevance. And of course, it will quite often be the case that the person who has the information you want, or the documents you want, is outside this jurisdiction. The situation was made more complicated because it wasn't entirely clear whether the court had jurisdiction to make this order against parties located outside the jurisdiction. And there were conflicting decisions at first instance on this issue. And it wasn't clear what was authoritative and what was not. This was also only a first instance decision, but it did endeavour to tie up all these issues. And in my view, it's likely to have done that unless the Court of Appeal turns its attention to this issue subsequently. And the way it decided was that Section 236 does not have extraterritorial extent. So if the person you want to apply against is in the jurisdiction, you're fine. And if they're elsewhere, you're not. However, there was a twist, which was based on the EU or EC insolvency regulation. In this case, it was the 2000 regulation which applied, but the recast regulation is in essentially the same terms. And because here the parties who were responsible to the application were in an EU member state, it was held that under the regulation, it was possible for the liquidators to rely on this provision, even though the provision itself didn't have extraterritorial effect. There are 2 consequences for that. So this case seeks to rule out extraterritorial applications which aren't caught by the regulation. So if you've got parties in Hong Kong, this decision would suggest you're out of luck under Section 236. So it's an important decision in that respect. The other looming question, of course, is what will Brexit do to this? At the end of the day, it's going to depend on what's agreed. The existing agreement, though, does mean that the regulation will continue to be relevant where the insolvency process already opened before the end of the transition period. So that's the end of this year. So the reliance on the regulation will continue for some time yet. So in my view, this is a case which has great importance for a wide range of applications that are very commonly made. It resolves or seeks to resolve lingering uncertainty, which will now, if it's going to be revisited, will have to be revisited at an appellate level. And it's a decision that will probably not be welcomed by insolvency practitioners. So for all those reasons, I think it's a particularly important case decided this year. Shantanu, I think you're muted.
No longer muted. I should have learned by now. Jonathan, thank you. That's 5 minutes exactly. I haven't had to use my imaginary whistle yet, but the rest of you are warned. Next is Matthew, who's going to talk about the distinctively named decision in Reaccurate.
Some cases are just so important that simply saying their name tells you all you need to know. The Quizclose Trust, the Tomlin Order, Roof and Park Damages. But in my submission, there's a new kid on the block, and it goes by the snappy title of Reaccurate Application to Restrain Advertisement by Winding Up Petition 2020 EWHC 1551CH. But for purposes of this talk, I'll refer to it by the entirely neutral title of The Winning Case. The winning case discusses the 3 main restrictions on winding up petitions in Schedule 10 to the Corporate Insolvency and Governance Act 2020. In summary, those restrictions are: firstly, creditors cannot present winding up petitions based on statutory demands which were served between the 1st of March and the 31st of December this year. Second, even if a creditor isn't relying on such a statutory demand, they can only present a winding up petition if they have reasonable grounds for believing either coronavirus has not had a financial effect on the company, or the company would have been in the same position anyway, even if coronavirus has had an effect. Thirdly, if it appears to the court that coronavirus has had a financial effect, regardless of what the petitioner believes, then the petitioner can only get a winding up order if the court's satisfied that the company would have been insolvent in any event. But how do these provisions actually work? Enter the winning case. The facts were simple. On the 24th of January this year, the petitioner served an informal demand for repayment of a £160,000 loan that had been due since early 2019. On the 27th of March, the petitioner served a statutory demand, and on the 1st of May, presented a petition. However, on the 20th of May, the draft Corporate Insolvency and Governance Bill was published. In advance of the first hearing, the company applied for an injunction to restrain advertisement. In response, Radcliffe Chambers' Lauren Creamer argued that the petition could still be pursued because the company was unable to pay its debts as they fell due, as evidenced by that January demand. However, ICC Judge Barber granted the injunction, and in my view, she made 4 important points. Firstly, prior to the first hearing of a petition, the court would readily grant permission to amend to allow the petitioner to rely on the fact the company is unable to pay its debts as they fall due. Second, in reality, unless you're very boldly trying to wind up Zoom or Tesco, few petitioners will be able to show that coronavirus has not had a financial effect on the company. In practice, this means that petitioners will almost always need to show why they reasonably believe the company would have been insolvent anyway. In the winning case, the petitioner did this by pointing to the age of the debt, the company's failure to respond to correspondence, and the company's failure to make even agreed interest repayments. Thirdly, Judge Barber said that once a petition has been validly presented, the burden's on the company to show that coronavirus has had some kind of effect. However, this is clearly intended to be a low threshold. The company does not need to show the pandemic was the or even a cause of insolvency. It only needs to establish a prima facie case. In the winning case, the company gave witness evidence that its funding drive had been halted by the pandemic. Importantly, even though Judge Barber had reservations as to the quality of this evidence, it was still enough to meet the low threshold. And finally, even if an injunction is granted, as in this case, the court may give the petitioner liberty to reapply later with further evidence that the company would have been insolvent anyway. In my respectful submission, the winning case should be your winning case today for 3 reasons. Firstly, it's another example of the courts applying upcoming changes in the law before they've actually come into force. At the time of the hearing, SIGA was just a draft bill, but Judge Barber still applied its terms. In practice, this means the winning case can help your clients rely on future protective legislation before it's even come into force. Secondly, compulsory liquidation still matters. Even though the figures are down about 2/3 on last year, there have still been over 450 winding up orders in the last 6 months. That's 450 cases which have had to consider the winning case. And thirdly, the winning case is widely acknowledged to be the most important authority on Schedule 10 of SEGA. For example, Westlaw labels it as significant. Even Bresco isn't given such a lofty title, and I'm sure we'll all agree that's conclusive proof the Poxy Supreme Court decision is much less important. For another example, the winning case has already been reported in 4 different law reports. That's twice as many as Moorgate Industries, which I'm sure will agree is conclusive proof that the winning case is twice as important. So for these reasons, I trust that you'll be voting for the winning case as your top case of 2020. But if you don't, then in true 2020 style, I'll be seeking an urgent injunction restraining Shantanu from certifying the results. Thank you.
Well, thank you, Matthew. We are, with those 5 precise minutes of argument, we then move on to Poppy, who's going to take us from the ground floor of the ICC list, I make no comment, Matthew, to the penthouse suite of the Supreme Court and the decision in Lonsdale and Bresco. Poppy.
Thanks, Shantanu. Yeah, so I'm talking about the Supreme Court case, Fresco and Lonsdale, which is obviously the most important case of 2020. The focus of this case was the compatibility between 2 statutory regimes. The first being the adjudication of construction disputes, and the second being the operation of insolvency set-off. With reference to the first statutory regime, that's Section 108 of the Housing Grants, Construction and Regeneration Act, which confers a right upon a party to a construction contract to refer a dispute arising under that contract to adjudication. On the other hand, Rule 10.25 of the insolvency rules provides for automatic set-off of cross-claims between a company in liquidation and each of its creditors, giving rise to a single net balance between them to be ascertained on the taking of an account. So how do these 2 regimes interact? Well, the background to this case was obviously a construction dispute, and one of the companies had gone into CVL, and then both subsequently raised claims for breach of contract. And Bresco, which was in CVL, served a notice of intention to refer the dispute to adjudication. But Lonsdale then obtained an injunction to restrain the adjudication process. And the 2 main issues and grounds of appeal for the Supreme Court to deal with were first, jurisdiction, whether the adjudicator had jurisdiction, and second, futility, whether it would be futile to allow the adjudication process to proceed. And the Supreme Court ultimately held that the adjudicator did have jurisdiction and there was no futility in the adjudication. Just to look at those issues a bit more closely, the first one, which was jurisdiction, the main issue was whether, since insolvency set-off replaces the former cross-claims with a single claim for the net balance, whether there is no longer a claim or a dispute under the construction contract, with the result that the adjudicator's jurisdiction under Section 108 or the contract was not engaged. So the Supreme Court here started with Section 108 and the contractual provision under the contract, and which is clear that an adjudicator properly appointed has jurisdiction to determine a dispute if it arises under the construction contract and has been referred by one of the parties. Now, the main submission of Lonsdale was that the effect of the automatic insolvency set-off was to replace all claims and cross-claims under the contract with one single claim to the balance, and so there wouldn't be a claim under the contract, but a claim under Bresco's insolvency. But the Supreme Court rejected this argument. They dealt with a number of the arguments that Lonsdale had made. Lonsdale relied on the single dispute rule, but the Supreme Court held this was misconceived. Even if a narrow dispute was referred, an adjudicator would have jurisdiction to deal with anything that was advanced by way of defence. The Supreme Court also, and I think this is significant, thought that it was an issue if a liquidator used adjudication to deal with one aspect, one dispute, there would be possibly a web of disputed issues, and liquidators could deal with these by different means, say by arbitration, litigation, adjudication. The Supreme Court also said that even if claims and cross-claims lose their separate identity and are replaced by a claim for the net balance, the underlying disputes don't disappear, and cross-claims still need to be considered separately for the purpose of ascertaining the balance. And they also held that if a liquidator can pursue a company's claims by arbitration, why not adjudication as well? The second issue was futility. So even if the adjudicator did have jurisdiction, what about because if the conduct of an adjudication in the context of an insolvency set-off will generally not lead to an enforceable award, will the adjudication process simply be an exercise in futility, which the court should restrain by injunction so as to avoid wasted costs on the process with no useful purpose? Well, the Supreme Court again rejected this argument. They said the starting point is that the insolvent company has a statutory and contractual right to pursue adjudication as a means of dispute resolution. And so it would ordinarily be entirely inappropriate for the court to interfere with that right. It also said that adjudication had become a mainstream method of ADR, which led to speedy, cost-effective, and normally the final resolution of many disputes for parties. Overall, it could be of real utility for liquidators when dealing with the process of set-off. The issues about the enforcement which were raised could be dealt with at the enforcement stage, if there was one. And finally, they dismissed concerns about costs and burden on the TCC because they said that actually those issues militated against admitting applications to restrain adjudications, just like the present one. So why do I say that this is the most important case of 2020? Well, first of all, it is a ringing endorsement for adjudication as an ADR process in construction disputes. Although the Supreme Court judgment recognises an underlying objective of construction adjudication was to improve cash flow on construction projects, so the sort of pay now, argue later, this was not the sole objective of adjudication, and it is far more wide-ranging as a ADR process than that. Secondly, IPs, insolvency practitioners, can now with confidence look to resolve disputed claims through adjudication where it's applicable in construction disputes. And this is great news for liquidators and administrators of companies in the construction industry, because adjudication is much quicker, cheaper, and actually rarely challenged, as the Supreme Court recognised. So this should realise a greater net return for creditors. Finally, I'd say that the importance of this case is already clear, even if you just look at Westlaw. The case only came out on the 17th of June, but it's already referred to in 4 reported cases on Westlaw. And the guidance has already now been given following Fresco on the use of summary judgment for the enforcement of an adjudication decision where the claimant was a company in liquidation. So for those reasons, I'd say this is clearly the most important case of 2020. And that is why I also ran over by 2 minutes, because it was that important.
Well, I was about to come to Poppy's rescue and say that probably the reason she ran over by 2 minutes is that Poppy used to be my pupil. And I think that she's probably learned everything she knows about going on for too long from me. But I'm going to try to avoid that now by moving on swiftly to Natalie, who's going to talk about the decision of Moorgate and Mittal by, I think, ICC Judge Burton. Natalie.
Yes, thank you, Shantanu. Yeah, so I'm looking at Moorgate Industries UK Limited and Mittal, which is a decision of ICC Judge Burton on the 19th of June of this year. So this case concerns a bankruptcy petition for a debt of nearly £140 million. And that debt arose as a result of an arbitration award that was made in the petitioner's favour against the company in 2017. Now, the debts of that company were guaranteed by Mr. Mittal and another Isle of Man company. And in commercial court proceedings, it was held that both Mr. Mittal and the Isle of Man company were jointly and severally liable for that arbitration award, the costs of the arbitration, and also the costs of the commercial court proceedings. So what happens next, in short, is that in May 2018, the 3 parties enter into a settlement agreement. And ICC Judge Burton decided that Mr. Mittal was in default of this agreement. and therefore he was liable to pay and could be pursued for the full amount of the judgment debt, minus any payments that had already been made towards it. So following that, Moorgate present a bankruptcy petition against Mr. Mittal, which they then later withdraw. And there is an order, or well, they agreed to pay Mr. Mittal's costs of that first petition in the sum of £66,000. Moorgate then go again. They serve a second bankruptcy petition. They serve it on the basis of a statutory demand that's prepared in October 2019. They present the petition in the November, and Mr. Mittal opposes it. Now, the three issues that come before Judge Burton to decide, leaving aside the issue of the construction of the settlement agreement, are first, whether Moorgate can set off the costs order of that first petition against the debt that's owing under the second petition, which is what they had done, or whether, as Mr. Mittal argues, the court should exercise its discretion and stay that second petition pending the payment of that costs order. The second issue is whether a defect in the petition could be cured with the use of Rule 12.64. And the defect in the petition on this occasion was that the petition debt had been calculated as a higher amount than the debt as it was stated in the statutory demand. And that was because Moorgate had included all the interest that had accrued between the date of the statutory demand and the date of presenting the petition. And generally, that's not how we understand Rule 10.9 and paragraph 12.2 of the insolvency of the practice direction. The third issue was whether Mr. Mittal should be given extra time to pay the debt. So Mr. Mittal was saying that he might be due some money in the liquidation of another company, and also there was an ongoing mediation, and that might produce a settlement payment for Moorgate, provided Mr. Mittal wasn't bankrupt. And also Moorgate would accept that sum in full and final settlement of the petition debt. So on these three issues, Judge Burton holds first, Moorgate was entitled to set off the cost award against the costs element of the petition debt. So the petition debt and the cost award was so closely connected, Judge Burton said, that it would be unjust to expect Moorgate to pay that cost order whilst Mr. Mittal remained so indebted to Moorgate themselves. It didn't matter that Mr. Mittal was jointly and severally liable to pay the petition debt. All that mattered is that he was liable for the whole sum in the same way that he was also liable to receive the benefit or the full benefit of that earlier cost order. And Judge Burton went further and also said, well, even if set-off didn't apply, actually, there is no authority that says you can't present a second petition whilst the costs of that first petition are still outstanding. And so therefore the discretion would have been exercised, or the discretion to stay wouldn't have been exercised anyway. And this is especially true where the merits of that first petition weren't determined. As to the second issue, so the miscalculation of the petition debt, so Moorgate tried to say, well, look, in our statutory demand, we claim the principal sum plus interest. And it's that plus interest clause that allows us to add on all the interest in the petition debt itself. ICC Judge Burton says, no, actually, this is a defect, but don't worry, we can cure it with the Rule 12.64 for two reasons. First, all we're really doing then is decreasing the petition debt. So that's not going to cause any prejudice to Mr. Mittal. And also, there's no real prospect of Mr. Mittal being able to pay either sum anyway, so altering the sum doesn't really cause any prejudice. On the third issue then, of whether Mr. Mittal should be given extra time to pay, Judge Burton revisited the decision in State Bank of India and Malia and distilled the three principles. The first is that there must be a reasonable prospect of the petition debt being paid in full. The second is that that must be within a reasonable period. And the third is that there must be credible evidence to support that prospect. And in the event, none of those things have happened. So why do I think this is the most important case of 2020, or at least in for a shout of that title? Three reasons. First is this case clearly demonstrates that the court is willing to make a bankruptcy order, even in the current economic climate. And that's perhaps in contrast to what we're seeing in the winders sometimes at the moment. Second, it affirms that we can't start squeezing through this additional interest that accrues between the date of the statutory demand and the date of presenting the petition, even if you have one of those catch-all plus interest clauses. And the third reason why this case is particularly important is it gives us an indication as to the options that might be available if you have an earlier petition that has already been withdrawn, but there is no order, but with an order as to costs. However, that might not bite in every case, especially where the second petition debt doesn't include any costs element. So that is Moorgate and Mittal.
Natalie, thank you. Moving swiftly on, James is going to tell us about the decision of what I would regard as a strong court of appeal, Nick Patton, David Richardson, Guy Newey in re Lehman Brothers, just when you thought that that particular gravy train had come to its final resting place. I hope that by saying that I don't betray any bitterness about never having been on that train. James.
Thank you, Shantanu. This case provides guidance on the rule in Ex parte James and paragraph 74, Schedule B1 of the Insolvency Act 86. The applicant was Lehman Brothers Australia in liquidation, and the respondents were the administrators of Lehman Brothers International Europe. And I'll refer to them imaginatively as Lehman Australia and Lehman Europe. Lehman Australia was an unsecured creditor of Lehman Europe, pursuant to an optional claims determination process developed by Lehman Europe's administrators. The two companies entered into a claim determination deed, which agreed Lehman Australia's claim in the administration as £23.35 million, and Lehman Australia was duly paid that sum. However, this figure was incorrect, and in fact undervalued Lehman Australia's claim by some £1.67 million. The error being caused by an incorrect currency denomination in a spreadsheet, which denominated part of Lehman Australia's claim in Australian dollars instead of euros, and accordingly resulted in an undervalue when that sum was converted to sterling. The administrators of Lehman Europe acknowledged this error, but declined to correct it in reliance of a release clause contained in the deed. Lehman Australia's liquidators applied to the court for a direction in Lehman Europe's administration that the administrators increase the agreed proof of debt. The directions were sought either under the court's inherent jurisdiction to control the conduct of its officers under the rule in Ex parte James, or the court's discretion to grant relief pursuant to paragraph 74 of Schedule B1. And interestingly, Lehman Australia expressly ruled out seeking rectification of the deed. At first instance, Justice Hildyard rejected the application, holding that neither power could be used to prevent the enforcement of contractual terms freely entered into by both parties. He was overturned on appeal, the judgment of the Court of Appeal being given by Lord Justice David Richards. The first issue was a correct application of the principle in Ex parte James. The 165-year-old principle states that the court will not permit its officers to act in a way which, although lawful and in accordance with enforceable rights, does not accord with the standard which right-thinking people or society would think should govern the conduct of the court or its officers. The Court of Appeal found that Justice Hildyard had misidentified the correct test to apply when using this principle. He had identified unconscionability, but this was not supported by the authorities. The correct test is unfairness. Is the office holder acting unfairly? Fairness is an objective standard, which the courts are very familiar with applying in many different contexts. The second issue was the application of paragraph 74. This empowers the court to grant relief where an administrator is acting or has acted so as to unfairly harm or proposes to act in a way which would unfairly harm the interests of an applicant. Lehman Australia's case was that the refusal to admit the proof of 1.67 million harmed its interests. Justice Hildyard had wrongly restricted the concept of unfair harm to where an administrator's act cannot be justified by reference to the interests of creditors as a whole or to achieving the objective of the relevant insolvency process or is discriminatory. The Court of Appeal held that paragraph 74 is more widely directed and applies an objective test of unfairness, there being no grounds to subject its provisions to mandatory qualifications. So, turning to the third issue, could either of these principles be invoked to prevent an administrator from relying on its rights under a contract? the Court of Appeal accepted that the existence of contractual rights are a highly material factor, but are not an absolute bar for relief. In all cases of ex parte James, and some of those involving paragraph 74, the powers were invoked to restrain an office holder from relying on strict legal rights arising at common law, in equity, or under statute. There were no grounds for excluding contractual rights from these powers. So turning to the application of the facts in this case, the judge had applied the incorrect principles and the decision was to be taken afresh by the Court of Appeal. Ultimately, there was no legitimate reason to deprive Labour Australia of its true entitlement on the agreed basis of valuing claims. So why is this an important case for 2020? First, it clarifies the application of ex parte James. The unfairness test will make it easier to invoke this rule than under a more nebulous concept of unconscionability. Second, it confirms that paragraph 74 of Schedule B1 is not limited beyond its text. And third, both of these powers are useful tools for creditors and can be employed in wide-ranging circumstances and, as we now know, in circumstances where a contract exists. So insolvency practitioners would be wise to consider any actions liable to cause controversy against the unfairness metric. Thank you.
James, thank you very much. Much to think about in those 5 presentations. I think I have a very clear view, if we had done it in a US presidential style debate, about who would have called at least one other person a clown. And that person is also, I think, the person most likely to appeal against other people having taken or been given more time to speak. But I'll leave you to form your own conclusions about who I think that is, and you may have your own views. Right, just like Strictly Come Dancing, the votes are now open, I think. I'm not operating it, I wasn't trusted with that. But you can decide what you think. Right. So the results are in, and perhaps surprisingly, I'm not sure, Reaccurate wins by a significant margin. It would be interesting to know why. It was the force and humour of the advocacy. Maybe that had some effect on the relative importance that it was thought to have, but that is an interesting decision, certainly not the one I would have predicted, either I think from having looked through the cases beforehand or having heard what my colleagues had to say about them. Very interesting. I hope everyone who has tuned in has thought that too, and maybe learned something, maybe occasionally even been entertained. It's now time for the next session. I'm going to hand over to Kate Rogers, who you already know, and who I should say was in one of the cases on which people have voted, and you've heard presentations about. Kate.